Welcome, everybody, to our Inside Settlement presentation today. I think we are live and ready to go. And I want to introduce our speakers that we'll have for you and then go through a couple of housekeeping matters. We have today with us both renowned plaintiffs and defense counsel. I'm thrilled to have them join me. This includes Chris Scheley from Clapp Maroney. Hi there. And we have with us Doris Cheng from Walk Up Melodia. We are together with you today to talk about inside settlement, literally the mechanics of mediation and strategies, some pro tips from folks that have been doing this day in, day out and are wizened trial lawyers. Those are the folks that can really tell us how it lands after verdict and what to do to settle before that. So quickly, you will get a link for your MCLE credits. Make sure to click that and fill out the form. Otherwise, you won't get your MCLE. And we have written materials for you today, but we thought instead of putting up a PowerPoint while we're talking, simply to focus on the discussion. And we will send a handout with our key points to you at the end of our presentation. So we're going to start up now. The first thing we wanted to tell you is that we're going to talk about tools for mediation, our top 5 tools for an effective mediation. We start, I'm going to lead the discussion by starting with mediation prep. And then I'm going to turn it over to both Doris and Chris to give you their real-time experiences. They're going to talk about actual cases, but they're going to anonymize them to preserve confidentiality, because that's the #1 rule of mediation. So my name is Judge Vedica Puri. I'm with ADR Services. I was on the San Francisco Superior Court bench and retired this year. I was a civil trial attorney for the 24 years before I was on the bench. So all of us here have been in many mediations. Mostly successful, but certainly some have failed. And that's where we've learned our lessons. And we're here to share some of that with you. So our first tool for an effective mediation is the prep. It sounds very common sense. Prepare for your mediation, but what does that really mean? There's a couple pieces to it. First of all, there is the pre-mediation call with your mediator, some form of conferencing that goes on ahead of time. For the mediator, it's invaluable because it is typically with lawyers without their clients present. And I will ask, tell me what are impediments to settlement, tell me where our plus points are. And it's really imperative that I have as much candor as possible with the lawyers to get ready. And I know that the trial lawyers here participate in that process all the time. So if the mediator hasn't set one, ask for a pre-mediation conference. Half an hour will do the trick typically. And if there are important things that you want to share with the mediator outside your client's earshot, this is the time. So that said, the next most important thing to me, and then I'm going to turn it over to the lawyers in just a second here, is the briefing. And sharing the briefing. I know that sometimes that's anathema to people. Well, why should I have to give up my smoking guns? You don't. But the mediator needs the lay of the land, as does the other side. They need to understand the strength of your case so that they can talk to their client about it. So sharing mediation briefs is not a sign of weakness. If anything, it's showing that you're willing to showcase your case and that you know what you're talking about. And here's the law that's going to help you in your pretrial motions, if that's what's happening, or if this is a business to business, there may not be hardcore litigation involved. You can showcase the key parts of the contract that you think are going to win the day. So the briefing becomes very important. One thing I used to do back in the day when I was a practitioner is I would actually do 2 different briefings. I would do one that would go to the other side, and then I would use that same brief and insert in highlights what I only wanted for the mediator's eyes. That way I felt I was getting my point across. I was preserving my smoking guns, but also telling the other side where I was going with the case. So those are just a couple of the things that I find very important as part of the mediation prep. Let me open it up so that we can have more of a moderated discussion. Doris, I'll start with you on the topic of mediation prep. Tell us what your thoughts are.
Well, first, I want to tell everyone how excited I was when Judge Puri went on the bench, because I had known her for a long time, and I know this community knows her. So it was such a wonderful thing to see Judge Puri on the San Francisco Superior Court bench. And now even more exciting to see you behind the scenes and getting our cases settled. So congratulations to you.
Thank you.
On this topic of the pre-mediation phone call, you know, one of the reasons I always call the mediator beforehand, and some mediators will handle it without me calling, but I always ask because I want the mediator to come in knowing something about the party, so they're not walking into the room cold. I don't know how it plays out for the mediator, because the great thing about the mediator is the vault, and she knows what's happening on both sides. So there's no reason to not to give her some kind of information beforehand, so she's not trying to read the room cold. I like to tell the mediator, this is how we got here. Here's who the players are. Here's what my client's like. Here's what the other side has been like in our discovery. Here are some of the conversations we've already had. So however that helps you compute like where the parties might be as we head into a discussion to get somewhere that resolves it. And it's not, I don't want Chris Scheley here, who I've had cases with, to think that I'm here trying to, poison the well or to influence her. The opposite. It's like the better off. We're much better off with her having as much information about us and our dynamic. I mean, an example is I had a case with highly contentious discovery, and it was a federal case. So we were always in front of the discovery judge. It's crazy. And I wanted my mediator to know that in advance, in case they wondered if there were barriers or just professional, mistrust of each other, because we've built a completely combative and adversarial relationship for, a solid 2 years. And now we're going to try to work together. So I wanted the judge to know, hey, if,
Heads up.
Yeah, heads up, in case I seem a little chippy, this might be why.
Pre-mediation calls are critical, and I couldn't agree more wholeheartedly with Doris, Your Honor. Not just to give the judge a flavor, but frankly, I like to talk to the judge about my problems. Because I can't talk about my problems in front of my client or the decision makers as freely as I can, speaking to the mediator directly and confidentially. So, a simple example is, I have one coming up, mediation coming up tomorrow, and my clients are absolutely adamant that they did nothing wrong. I mean,
imagine that.
This is a defensible case. You're going to defense this 9 out of 10 times. And fortunately, the decision makers are not quite as wed to that concept. But I had to explain to the judge, who we're going to be appearing before, that I'm going to have to come out hard and strong. And here's why. Don't be taken aback. Don't think that this is an impossible task. I'm just setting things up, and I'm going to need your assistance in explaining the facts of life to my clients. And so those kind of pre-mediation, smoke signals or, FYIs are critical, whether it be, and then the other thing I will tell you is, I'm very transparent with the mediators, primarily because mediators that I hire, I trust. And so I would have no difficulty talking to Judge Puri and saying, look, I see the vulnerabilities in our case, and I recognize this issue. And I've had judges say, well, then what am I supposed to do? And I say, help me, help others, and then try and find money from some other people too. That doesn't hurt. But pre-mediation calls are critical, and I don't know why every mediator doesn't do them. But if they don't, I agree with Doris and the judge that you call up and kind of request it.
Absolutely. Now, folks, talk to me a little bit about your briefing style when you're, whether it's a major catastrophic injury claim or even your smaller matters. I know both of you generally do only large matters, but how do you handle your briefing for the mediator and for the other side? Doris.
Well, from a defense standpoint, it's critical that the plaintiff's attorney, the person asking for money, whether it be in a personal injury case or a commercial matter or transactional or any number of different types of civil litigation cases. If you want money, you've got to help me educate my clients and the decision makers. And whether it be a corporation or an insurance company or a small mom and pop business, there are layers of decision makers that I have to go through and I have to educate them. And so it's really important that I get from the adversary documentation, whether it be in the form of expert reports, economic evaluations, forensic accountants, things like that, who can give me evidence that I can then share with my client so that the decision makers can see what they're facing. It doesn't help me at all to get a life care plan or an economist's analysis that morning, because corporations and insurance companies and public entities are bureaucracies, and there are a lot of chefs in the kitchen. And in order to get decisions made, it needs to go up several ladders. The bigger the case, the higher the ladder I got to get up. So
Chris, talk to us a little bit about timing. I mean, understanding you have to do your own analysis and then make your way through ladders. So the traditional mediation brief, 7 days in advance, does that do it? What is your recommendation to folks depending on their ask?
Yeah, I mean, it all depends, of course, on the nature of the case and the issues that are involved. But if it's a personal injury case, the sooner I can have expert reports on the plaintiff's condition, future diagnosis, prognosis, treatment plan, and then life care plans and voc rehab reports. If I can get that 30 to 45 days before the mediation, we have a way better chance of having a successful mediation.
So Doris, leading off on that, that's a lot of work for a plaintiff to put together and then disclose that you're giving a roadmap to your case. What are your thoughts on briefing and trying to get things early and often to defense counsel?
Remember that the settlement negotiation is coming up when it's ripe for resolution. So, like I said, Chris and I have worked together before, and the conversation about settlement and adjusting his expectations is long before we get to mediation. The mediation is just a show with everybody else. But in our cases, I would have sent him my life care plan if that's what's required, because a lot of our cases, or all of our cases, are injury cases of some kind or another. And so if I have a long-term injury, he needs to know that my number for the economic damages that I'm claiming are whatever they are, so that and I want to do that because I've got to start planting that seed early. He has to get conditioned to the number being really big, because if I give it to him the last minute, it's, we say that crisis is something that has a short amount of time for change, and transition is something where there's a long amount of time for change. And my goal is for everybody to get towards that place where we're going to end up in the same part of the Venn diagram. And so I would say that, especially when you're dealing with lawyers that and we can talk about dealing with lawyers and lawyers you don't know. With lawyers that I know, so often I will send that damages analysis well in advance of even doing any discovery, especially if I already know that. If I don't, I've got to do that at some point. It means I'm behind. And that's not a criticism. That just means that's kind of how life falls out sometimes. But if you want to have a fruitful mediation, then those things need to be done well in advance. And then the brief itself, like I said, with lawyers that I know and I worked with, and they understand California law and they understand this type of work, that conversation has been evolving before we got to mediation. So that by the time that I send my mediation brief, who's my audience? Is it Chris's carrier? Is it the mediator? But in all likelihood, it's not Chris. He has seen and heard this show already. And so I try to put as much as I can to influence the people that I'm interested in paying the money. Now, for people that you don't know, then you make an election, and here's the little quandary. So, if you have a lawyer who either is new or is not new at all, but doesn't know this area of law, you have to make that decision as to how much you trust yourself. If I give all of this information, how are they going to use it to hurt my client? More often than not, it's going to help your client because it will convince them that they should be resolving it with you. There is, I think, sometimes the downstream problem, especially if you're dealing with, and sorry, but big law, where, it turns into a billing machine that you can't control. And sometimes it's better not to say anything. So I think you have to gauge that it's a game time decision, and there's no absolutes on that. But generally, I would say if you want to maximize your result, they need to know potentially what's going to happen at trial. And so the briefing, as I said, should, by the time that you get the brief, none of it should really be a surprise. I hope that I have done a good enough job either in the discovery and litigation showing where we're going with this and why it's a valid and high exposure case.
That really transitions well into the next kind of category, I think, Your Honor, which is preparing your clients for mediation. And if I have that brief or that backup documentation, I can go to the decision makers. I can identify who it takes a while to identify who the decision makers are. So, for example, if I've got a corporate client, one person may have authority up to, say, $500,000. But above that, you got to go to another executive rung above them. And, for several clients, if we're looking at seven figures, I got to get the CFO and the CEO's approval. And if I'm representing a public entity, I got to get the board's approval. And so, it's not like there's one person I'm talking to in these kinds of cases. In many cases where there's multiple insurers, tower of insurance, I've got, layers up to like 15 different insurance companies, and each of them have a monitoring attorney who are asking me as a defense attorney, have you done this? Have you done that? What about this? What about that? So that information, if it's voluntarily provided, it just makes things way easier and more fruitful at mediation.
And Doris, from your perspective, preparing your client, you may not have a lot of levels, but you have another whole schmagilla of issues that you're handling. Talk about that.
I get to pick my clients more so than Chris does. And so the expectations are from the beginning, I hope. I hope what I've done is a good job of, having honest and real conversations about what does the law provide, what are the things that we can accomplish in your case. And if we can't get those short of trial, then we want to be in trial. There are times when the settlement discussion, we're just not in the same place. And there are, different desires that people are trying to achieve. And I would say for my clients, and just the practical realities, like I said, there's conversations that go on very early, but, before we actually set the mediation date, there's a conversation with my client that this is happening and what we are trying to accomplish. So, hopefully it's big picture with your clients too, I would hope. And then the week before mediation, if not earlier, some of my clients are very curious, well, what's going to happen? What's it actually going to look like? And so you need to just relieve their anxieties about that. But at least a week before, I want them to know this will be by Zoom, as an example. We'll be in a different breakout room, that you can say anything that you want to the mediator, because, if we trust our mediator, which we pick good mediators, and, I'm glad Judge Puri's among them, we'd say that the judge will not tell the other side anything that you say without our permission. So I have no concern if you have questions or anything else. And I want them to feel like this is a just process, that they should have faith in the American jurisprudence, and that we do have still yet a better system than other places. So I want them to have that trust, and then explaining, because everybody gets worried when they don't know what to expect. And I think just knowing what to expect, like, go ahead and put out let them know you should bring a magazine, you should bring your laptop, you should be fully anticipating that you're going to do nothing for some period of time when the mediator's in the other room. So I think the management of that expectation, and also to let them know that whatever is the first response to our demand is not as important as the second and third, because then you're really seeing what they're messaging. And I think we'll get to this discussion about moves, but much of the mediation is not about, tit for tat. It is about, what are you trying to communicate about, where do you want to end up?
That's exactly right. So folks, I think what you're hearing is on the topic of mediation prep, whether it's the pre-mediation call, whether it's the briefing or the prep of your client, the prep starts very early in the process. The mediation date is when all that culminates. So we're talking months and months ahead of time. Now we have a great question that I'm going to open up to our trial lawyers here. The question is, what are your thoughts on whether to pursue mediation early versus later in the case? Now, this is a key question. The really schlocky answer is, it depends. Of course, it depends on the facts. It depends on the liability. It really does depend on a lot of things. But I will tell you that if both sides are open and willing, there is no bad time to do it. So that's my answer from a private mediator standpoint, and having done a lot of mandatory settlement conferences for the court, which I will also talk about in a minute. But starting with you, Doris, what are your thoughts about early versus later?
And exactly what you said, Judge Puri, it depends. And some cases lend themselves to very early settlement discussions. Now, mind you, there are some cases where it's contractual. You may have signed a release or some sort of, agreement. Like I had a wilderness outward bound type of case where when the parents sent their child off to this, 3-week child, you're essentially giving custody over for 3 weeks to this organization. And built in that contract is, before you bring any claim, there is contractual agreement. There's a contractual agreement that we go to mediation first. And it even says we'll go to a certain provider. So sometimes that's in the cards, but other times it is, the case is so obviously indefensible that, that's not often the case. And there'll be some response, but I'm saying that in the big picture, this is pretty clear to everybody that it's going to get settled at some point. So do you want to try to do this early with both sides, trying to do that? I have a case that involves a young man who attempted suicide in a care facility. And the care facility, there's information in the records indicating that they knew he was complaining about suicidal ideation, and he was a minor at the time. They were supposed to get him off to the hospital, so a specialist, a care provider, and they didn't. And that's one where I think everybody knows this should never have happened. We should have a conversation, right? And then there are other cases where the fight is going to be on some issue, and it is, and you're not going to be able to get it settled until people do some amount of homework, whether it is discovery about liability, or if you're doing contract cases, it's going to be a fight on interpretation, or if it's going to be a fight about the remedies. And that people won't agree, either because of personality, precedents, they've never settled this sort of thing before, or precedence because of whatever the law has been in the past or something. And that's going to take some homework. So that may be later, but I don't think it ever hurts. And what I really love about my defense attorneys that I have great relationships with are when I file the case and they get the case, because I don't know who gets the case until they show up. But they call me and say, I'm on the case. Let me know if there's anything you want to talk about. That is one of the most helpful things. And that helps both of us decide, how much work it's going to take for us to get to some place where we're going to see resolution.
I was going to say that whether to go early is dependent clearly on the complexity of the case, but also who's on the other side. And if it's somebody you know and trust, and they're going to give you the information you need to evaluate the case, then, and if it's relatively straightforward, then by all means go for early mediation. If another reason to go for early mediation from a defense standpoint is if you have attorney's fees involved. So I hate those cases that involve landlord-tenant disputes, but we seem to get them because of the conflicts that arise due to coverage issues. But what drives those cases is attorney's fees. And so the longer you conduct discovery, the higher the price is to resolve the case. Similarly, discrimination, harassment cases where, when attorney's fees are involved and you have potential exposure, I'd recommend early mediation.
That's great. Another question on this topic is, what can the trial court do to position the case for a successful mediation? Okay, well, having sat in trial court, the answer is a lot if we're given the tools. So, for example, if there's a motion, a summary to dispositive motion that's teed up, obviously that can help, decision can help sway the case one way or the other, depending on where you're in your case. The other thing the trial court can do and will do is send you out to a mandatory settlement conference. Now, that's in San Francisco Superior, that's typically with a judge. And there are varying thoughts on the effectiveness of a judicially mandated MSC. Sometimes the case is not ripe. Sometimes people feel that they're given short shrift because a judge only has so many hours in a day that they can devote. I will tell you, frankly, when I did civil trials for a few years there at San Francisco Superior, one of the first things my presiding judge came to me and told me was, Judge Feng, whom I love, says, hey, so by the way, you're going to do MSCs. And I was like, hey, that sounds great. When? Like, do I get a couple days a week? And he's like, no. You do them before work, during lunch, and after. I was like, wait a minute. So
that sounds like Judge Feng.
It sounds like Judge Feng. And I thought, this is never going to work. And I have to tell you, that's frankly what led me to this career. Is I loved it because we were under a time pressure. I'm like, guys, I have 1 hour in 8 a.m. to 9 a.m. Let's go. Then I'll see you again at 12:30. They can actually be quite effective, if I may make a pitch. So depending on what court you're in, if you really feel like you need to raise your hand and be like, gosh, this would be worth some kind of effort, do not feel ashamed to ask your judge, hey, judge, what's the settlement conference program? It is not a sign of weakness because who knows what will happen then. But so the trial court can absolutely help, whether it's teeing up a motion, whether it's sending you to a settlement conference. If you're close to trial, motions in limine are critical. If you have strategic motions in limine pending and you've had a single assignment, direct calendar judge who you get in there and say, listen, Judge Puri is going to say ABC, we're pretty sure. What about a pre-trial settlement effort before these motions in limine get decided? Of course, there's after the motions in limine get decided. There's during trial. There's all kinds of points in time where the trial court can exercise its discretion, but we do need a motion. We need something affirmative from you to be able to help move your case forward or back, whichever way you're looking to do there. So that's my answer on the trial court. Chris or Doris, do you have any additional thoughts on how a court can help you move towards settlement?
Well, each court seems to have their own kind of program, Your Honor. Santa Clara, will send you to a pro tem judge a week before trial, whether you want to go or not. San Francisco, I think if you ask, they'll set it up. But again, that's usually through a pro tem. Alameda, I think, orders you to MSCs. So look at the local rules. and see what the local rules say about the court and ADR, and use those tools.
Good point. Every court does have a separate local rule on that. Doris.
We have a rule: trial dates get cases settled. We're just hardwired. That's the truth. Not to do anything until we have to. And the truth is, most of us are so busy that unless somebody says, here's a deadline, we won't do it. So trial dates get cases settled. As the trial court, I think there is always the balance of what we want from our trial judges. So give me a trial date, but at the same time, be flexible, recognizing the pressures of what we do. And we all want to do a really good job. And so if we're, not quite ready for trial because we are trying to settle, I would say to the trial judges, listen to us. We know the case is better than you ever will. And I think your job is to suss out, really what's honest, and not that anyone's trying to be dishonest, but what is, delay, a necessary delay, versus necessary delay. So I think that's one. I think when you're at the CMC, I think courts should always suggest some sort of ADR, because again, it puts it on the minds of the parties. And then it's up to us. I mean, I have some cases where the defendants will say, I can't, I have no authority. And they have, maybe it's a professional negligence case. They need to get consent and they don't have the consent. So it's not going to help if you order us to mediation anyway. And I think you have to, as the trial court, you need to listen to those things. And as I say, recognize which of those is genuine and not making us, as the lawyers, like spin our wheels. But then the MSC process, I think San Francisco has been great with having each of the judges try it out, having the imprimatur of the judge, and also recognizing that the judge is seeing jury trials, what's happening on our bench and what cases are going out and what the verdicts are in the courthouse. So there's a lot of value to that. I think it's great when you have ABOTA members, which I know a couple of counties have done, American Board of Trial Advocates, and Chris and I are both involved in that, involved as pro tems, because it's helpful when I think real trial lawyers know what risks and exposure looks like, but it doesn't mean all of us are necessarily good mediators. And there's a lot of times that I would rather be diverted to a judge than a pro tem, or the judge heavily suggesting that you go to a mediation. And I will just say, for the courts, you can't force people to go to mediation. There's case law on that. And so as much as you can encourage it, the backup is a good MSC system that, as I said, there are many trial courts that have implemented great systems.
Doris,
I remember the old days. It was mandatory.
Yeah,
right.
And I'm dating myself, but there wasn't a courthouse you could go into and get a courtroom until you went to a mandatory settlement conference with a judge. But judges are too busy now, so hence ADR and Judge Puri.
So the other thing, Doris, you raised a good point. In your CMC statement, there is usually a requirement of the format for, particularly on a complex case. And there is usually a line that says mediation or settlement efforts to date, ? And that's a great place to signal to your trial judge. We have not discussed it yet. Let me tell you, as a trial judge, I would look at that and be like, okay, let's talk about it. So Doris is absolutely right. Use your CMCs to flag the issue and hopefully get the judge's attention on it. Okay, so folks, we're going to now transition to the 5 tools I was talking about. I don't think I told you what the 5 tools are. So we started with mediation prep. Number 2, we're going to talk about in-person versus Zoom. Number 3, we're going to talk about the efficacy of a joint session during mediation. Number 4, we're going to talk about presentations during a mediation through an expert, by plaintiff's counsel. What's the value? When do you do it? And then finally, we're going to talk about the utility of, this mediator ain't helping me anymore, direct counsel to counsel discussions and whether those should happen and could happen. So we're on to in-person versus Zoom. That's our next topic. I have a bias as a sitting judge when I was on the bench to The more you're in person, the better. Of course, I will take your Zoom appearance. Of course, I will get the calendar done because it is helpful for transportation costs, for all kinds of reasons. Your client may be far away and it's not feasible for them to come. But if you are litigating an important matter and you have a dispositive motion, a head turner of a motion in limine, a critical jury instruction that you think is really important, I think it's critical to be in person. So translate that rule over to mediation. Same thing. To me, there is no substitute for the eyeball to eyeball. But that said, obviously in the COVID era, we have gotten very good and very efficient at doing Zoom mediations. And again, it can be a comfort for your particular client to know that they don't have to schedule a day of travel back and forth, that they'll be right there in the room if you want them to be. So my preference is always in person as a mediator, but I completely understand the complexities of real life and how Zoom mediations are important. I'll tell you, the last mediation I did was a hybrid. We had I'll call them the sticky party in person so that I could make sure to hold their feet to the fire. And we had the easier party by Zoom. They felt that was equitable and both sides agreed. And it worked out just fine. I was able to run into the sticky parties room when I needed to and come right back into my Zoom room. So there's ways to make this all work. But that's my preference on that issue. So I'll turn it over. Chris, starting with you. What is your thought on in-person versus Zoom?
If it's a high stakes case or an emotionally charged case, I insist on in-person. For a variety of reasons, not the least of which is I want my client to see and observe the other folks involved in the case, and particularly the plaintiffs. And I want to provide my client, when appropriate, with the opportunity to express, their feelings of compassion or sorrow or apologies. I had a bad case involving a big, manufacturer of motor vehicles, and the plaintiff was badly injured. And my client, corporate counsel, said, I want in person because I want to go there and I want to eyeball the plaintiff and his wife. And I want to tell them how sorry we are as to what happened. Not that we felt it was our fault per se, but recognizing the gravity of the situation and the seriousness of it, and telling them I'm here in person because we care. And that set a bond at the beginning of the mediation that continued through the afternoon and into the evening, and we got that case resolved. And had we not been in person, had that not happened, I don't think the case would have resolved. So, and then emotionally charged cases, if it's sexual harassment or sexual assault case, something like that, I think it's important to have a mediator sit with the plaintiff and let them tell their story, and you can't tell your story. I'm sorry, you just can't tell your story on video.
Got it. Over to you, Doris.
I also prefer in person. I mean, maybe if this is the second or the third mediation and the parties maybe already know each other, the benefits, though, certainly of being in person. One, whether you're doing a big commercial case or a smaller or individual case, I should say, right, without multiple parties, having people see each other, hear each other, it informs how we think they're going to perform at trial. And there's a lot of information that you're gathering, as we always talk about how to read the room. There's intel you're gathering, as you size up everything. I don't just mean the people, but the whole circumstance, the whole situation, what is going to be the heartstring tug, what's going to be the credibility tug. And you don't know that when you're on Zoom because you'll never interact with them. You won't even do a joint session by Zoom where people will genuinely reveal themselves. And so I think it's always more helpful to be in person. And I would say the convenience factor is really kind of up to the parties and how much control you have over your client. You know, I had a copyright case some time ago. And so not just personal injury, but now you're dealing with people who have very strong feelings about the way they run their business and the contracts they have with other people. And, you know, there were reasons for them to have very, very strong positions about why they weren't paying, whatever symbolically that meant. And in that circumstance, I think it was really helpful to have people in person, which probably dovetail to the next thing or something else later about whether you have, you know, a lawyer to lawyer conversation at some point, which is made easier when you're in person than when you're by Zoom.
Well, and also a joint session where you can go in and out of the room, right?
Let's talk about that. It moves right into the next topic. I think what all of us are saying to you folks is that there are nuances that you will pick up on in person for your client, that the mediator will pick up on, that there's no off-camera option. So unless the person's storming out of the conference room, you're going to see their reactions real time, and it's very valuable. Okay, moving to the joint session. Let's talk about this in the, I'd say olden days, talk about dating myself. There was a very routine practice at mediations, private mediations, where you bring both sides in, lawyers and clients, around a conference room table. The mediator kind of leads the discussion, gives both sides an opportunity, the lawyers, to talk. And sometimes that's really just not productive, is what we have found. I found it in my own practice when I was a trial lawyer. I thought it was just a lot of chest thumping. I thought it did not help. If anything, my client would get even more entrenched in their position, listening to kind of an opening statement at 9 a.m. And so it would not, to me as a mediator, I generally don't do the joint session. I kind of say, everyone, we're going to roll up our sleeves, going to keep you in your own conference rooms. I've talked to you. I've read your briefs. Let's get going. Now, that is the way I typically do it, but I have been asked on occasion that, I think, Judge, maybe we could do a joint session, and maybe it's not at 9 a.m. Maybe we come together a little bit later, but there are different schools of thought on how to do a joint session and when to do it. So let me open it up. Chris, I'll start with you.
So I agree that joint sessions, particularly the joint sessions that we used to have where, opening statements or closing arguments were made by both parties were counterproductive, because everybody would get, their neck tightened and their fists clenched and let's go to war. So those are not helpful at all, in my opinion. However, sometimes I think it's important for the defense and the decision makers on the defense side to meet the plaintiff, to look at them and see them, and if nothing more, just share pleasantries and hellos and, express concern and express your intention and your desire to try and come to some kind of resolution. And that softens things, also gives your client and decision makers an opportunity to kind of see how this person is going to present in front of a jury, which is what it's all about.
So Chris, will you ask for a joint session if that's not where it's going with your mediator?
Absolutely. Yeah. And usually I'll do it before the mediation and just say, hey, just previewing. I know people don't like joint sessions, but I've found them to be helpful in some circumstances. And I think this could be one of them. And here's why. And then, obviously I follow the lead of the mediator, because the mediator can read the other room. I may not have a good read on how they would react to that. So I follow the mediator's lead, but when I think it's appropriate, I nudge the mediator in that direction.
That's great. Doris, what are your thoughts?
Oh, I think I would say I rely entirely on the mediator for the cue. Tell me if this is going to be helpful or hurtful. And sometimes the defense asks for it because they have been talking to their client. The mediator has talked to them, and the client, I think the defense client, needs to know if the plaintiff lawyer can actually deliver. And so sometimes having that in-person conversation, but this is, you've had gauged the situation, because there are some lawyers who can't deliver. And then you don't
Right.
want to suggest that. Like, this is not
Exactly.
going to help. But if I articulate it myself, is this going to make it better or worse? Am I going to come across as too strident, or that I'm not giving an inch? Or is that actually what's needed? Because they need to know that we aren't moving. And some people need to know that. I think the most important thing about the mediation process is that as you're communicating, nobody's being misled. That doesn't mean you're telling them everything in the world. It just means that when I give you my response, it's so that you're not thinking what I really want is X when I'm asking for Y. So it's, I take.
It can lend clarity, is what you're saying.
Right. And so, as I said, that I think those are the reasons for the joint session. I mean, do they need to see something that they're not getting already from the briefs, or from what the mediator is saying, or from what their own counsel is saying? Is there something else that's going to add to it to, get past whatever barrier is in their head?
Yeah, and you can accommodate a joint session, or a presentation or a joint session in such a way as to not get people's defense systems
right.
up. For example, I'll say, look, my clients don't want to be in the room, but the insurance company reps do, or I think we need to show the insurance company reps your presentations so they can get a flavor of what's going to happen in court. Those can be helpful, but again, everybody's got to be on board with it, and it's got to be vetted by the mediator, and to make it effective.
And I'll tell you, the one thing I look for, most important to me, is the relationship between the lawyers. If it's so acrimonious, like Doris was talking about the case where it was 2 years of just absolute bitter fighting, that may not be, if we're coming up on a mediation, the exact right route to go, because I've got lawyers who are warring. So I look to the relationship with the lawyers, their past history. Are we at a point where there's not that kind of acrimony, such that this would be a productive use of time? All right, so speaking of productive uses of time, we go to our next topic, which are, now we're in the mediation. We're going back and forth. We've finished our, whatever it was, if it was a joint session or if it's just a roll up your sleeves, let's get going. And we're making moves. There are numbers being thrown out. An interesting point that we have all talked about before, that's Chris, Doris, and myself, is presentations. If, when, how, and by whom. Can a presentation, for example, let's start with experts. You have your expert there, live, ready to go. Yes, you're investing that time and money. That's a big dollar sign but you're having them there for a reason. Is it going to be persuasive? Is it giving up too much of your case? These are important strategical moves that we need to be thinking about, so that they're teed up again. It's part of the prep for the actual mediation. And will they be helpful? So let me start with expert presentations. I know both Chris and Doris have been in mediations where they have used this or seen them. And I'd like to hear about those results. Doris, I'll start with you.
So the presentations are never accidental. And there has been, if it's the first mediation, there has been some discussion about it already. That goes back to, I would say, if you have a relationship with the opposing counsel, they're going to give you a heads up about that. If you don't have a relationship with the opposing counsel, I'm going to encourage all of you to start doing that. I mean, make it part of a habit in the way that you practice law, because this really still is a human experience. Every part of the law. It doesn't matter what our cases are, whether they're contract cases, transactional cases, there's a human element to it. So if it's going to come up and, they want a presentation, then you have to decide in what format. And mostly, I would say interestingly, I had a case not too long ago where the other side wanted to have their expert show me their cards. Now, that was interesting. I'll tell you, I think part of the reason was because I don't think the lawyers could have delivered or articulated the information themselves. I think they needed the expert to do it, but then they wanted my expert to do a presentation so that the two experts were talking to each other. And I think you have to be careful about that, whether you agree to that or not. Some cases may lend itself to that. My feeling is that I am the trial lawyer, and if I can't explain it to you, then you shouldn't pay me because I'm going to lose that trial. So, and the other thing is, I don't want you asking questions of my expert. You don't get free discovery, and I'm not turning this into a Daubert hearing or a mini arbitration. This is not what that's going to turn into. So I would say, have in your mind, what are the parameters? What's going to be helpful and cooperative, but not detrimental? And when we talk about mediation, we're all talking about actually trying to resolve something in a cooperative fashion, but that does not ever mean, you're giving up intrinsic rights that are detrimental. We give up rights to settle, but not ones that are detrimental to your client.
I would just add or comment, Doris, that the cases that you and I handle generally do not lend themselves to experts sharing information. I have used experts to try and, convince the other side of, particularly persuasive defense that I think I have in cases to kind of get the ball over the line if the mediator and I think that's going to be effective. But, in CD cases, not that I do those, but a lot of my partners do, it's kind of, I think, standard or custom and practice to go to mediation and have your experts involved. And it's protected by the mediation privilege, and, they kind of work out a fix or whatever it may be. So I think, it depends on the nature of your case. Unfortunately, I don't do CD. So.
Yeah, I had a recent case where, and I thought this was a good idea. The one side who said, I think it's going to be really effective to have my expert there. They've got a great presentation, great demeanor. We did a preview session, just 20 minutes, so nothing crazy or long. And then afterwards, we excused the expert, and the lawyer asked me, what do you think? And I said, I don't think this is going to go well. I think you think your expert is a little bit more fly, shall we say, than they really are. I don't think this is going to come across. And they ended up not using the expert. So that's another way to do it too. Maybe get the mediator to help you be a gatekeeper if your thought is, boy, this is going to really do it. Because when we're trial lawyers, we're so invested in our case and our side. And of course, we're realistic. But on the other hand, you're so wedded to what you're doing, you may not have exact perspective on how someone is coming across. And it is like Doris was mentioning, the thing that all of us are gauging, the mediator and each side, credibility. How are folks going to play at trial? How are they going to look? How is a jury going to read it if it's a case that's going to trial? So all of this becomes important, particularly if you're previewing your expert. The first thing opposing counsel is going to say is, well, let me see how this guy would hold up on cross. You're not going to allow that. So it's an important feature to add in, particularly if it's a complex case, if it's going to help persuade the decision makers on the other side. So use your mediator to gauge, but it could be something very helpful. The next type of presentation that could also move the needle is by plaintiff's counsel. Again, plaintiff's counsel is the one that's demanding the money. Their credibility is being gauged by the defense, and boy, am I going to have to go up against this formidable plaintiff's lawyer. I don't want to see her opening argument. This seems too hard. Yes, let's settle. So what are your folks' thoughts on actually, so just quickly on the timing, folks, I think we have another about 5 minutes left. I think we started at 12:05. So we're going to be wrapping up pretty shortly here. If you have questions, please type them in for us. We're happy to field them while we keep talking here. So plaintiff's counsel presentations. Chris, have you asked for those in the past? And then, of course, we'll turn to Doris to say if she's actually done them in the past.
I have, but again, it kind of gets back to who are the decision makers? Are they comfortable with it? I vet it with them. Is that something you'd find helpful, or is it going to, upset you? And then I vet it through the mediator. And I also, it depends on who the plaintiff's lawyer is. If it's a plaintiff's lawyer who is incredibly arrogant and it's going to come in pounding their chest and ridiculing my client, then no thanks. But if it's somebody like Doris who's going to give a presentation in a calm, convincing, persuasive manner without being, confrontational, then it's something that I might recommend in the right case.
Doris, what's your thought on presentation?
It has to be respectful. So I'm really glad Chris said that. You're trusting the other side to, give an audience to your clients. So I have to have that, EQ in the room, that I'm not there to insult them. And I'm, like Chris said, you have to trust the other side on that. And similarly, if they're going to do one to my clients, as one example in that case, I was talking about where they wanted the experts to talk and they wanted my clients there. And it was a really sad, terrible, tragic case. It was a death case where the person burned up. That was the cause of death. And you know what? I'm not putting my client in that situation. They don't need to relive this. So I think as the lawyer, you need to have, as I said, just good boundaries for yourself. And then the presentation, another example is an abuse case where I think they needed to see how I would argue this case. I mean, there was the back and forth arguments in a vacuum, right? The tit for tat that happens with a mediation. The mediator says, well, they're saying this. And then you say, this is my response to that. But to hear even 7 minutes and not more than that, I would say people, they need a flavor for what is coming, but they don't need a 30-minute presentation. And frankly, if it's 30 minutes, you've lost them. And I'm, probably thinking that maybe you should go to trial against her, Chris. 30 minutes, like, oh, you're welcome.
Yeah.
For the folks in the audience, what you're hearing is it's an option. And if you have a good enough relationship with opposing counsel, talk to them ahead of time and say, would it help to do a 15-minute dog and pony show by this expert, or would it not? Talk to your mediator ahead of time, because this is another tool that could be used to move the needle forward in a sticky case for a mediation. All right, our final topic, we're going to take this slide down and just go back to the basics. Is there a point in time where maybe direct counsel to counsel discussions are what's in order, even if it's during a mediation? I would say absolutely. There comes sometimes during, we're at 3:30, 4 o'clock, people are caffeined out, they've had the cookies, they are just at their wits' end. Lawyers don't feel necessarily like the mediator may be hearing them. And it may be time for a mediator to either have the self-awareness to say, maybe I just need to get you two lawyers in the same room. Or for one of the sides to say, Judge, can you just give us a minute here? Maybe just step out for a second. Let me talk directly to lawyers. There is no shame in doing that from the mediator's perspective. I don't feel like it's a failure. I feel like maybe we've reached a certain point where then that could be productive. So turning it over again to counsel who actually done this. Doris, I'll start with you. Have you actually in a mediation said, time out, I just need to talk to opposing counsel?
Yes. And a couple of times, like I said, kind of directing it back to the mediator, is this a good time to do it? And I offered that. I said, you tell me when is the right time for me to have a direct conversation with this person? Because when I said it, I meant it. Do they need to hear that from me? And I would take my direction from the mediator. So that's happened. That just happened a week ago in a case where I thought, frankly, I'm going to be honest, I thought the mediator was like going a little bit long. And I was like, can I shortcut this? Right. I think I might be able to shortcut this. And then the other occasion is when the mediator comes in and says, there might be a place for you simply to say what you need to say to them directly. And I think that would be a good idea. And I had one case, and Chris knows this mediator too, who actually told me, okay, I don't think I can help anymore. I'm going to have lunch in the lunchroom. You can just go meet with the other attorney. Feel free to use that conference room. And then both of us, the other lawyer and I, were like, well, I guess he made the right call, because we're not getting anything done with him. But it gave us the bonding that we needed, interestingly, and we got it done ourselves. So I guess you could credit the mediator.
I had a very similar situation years ago where
possibly the same person.
Well, not exactly, but similar. But she was saying, I can't get it through their heads that if they get a verdict, it could be a Pyrrhic victory. And I had to go in there and talk about coverage issues. I had to talk about conflict issues, and I had to explain how, without throwing my client completely under the bus, explain how yeah, you're going to get a verdict, but you're never going to recover a penny. And the mediator couldn't quite do that. So,
Yeah, and sometimes that's exactly right. So use that as a tool as well, folks. Just know that there could come a point in time where you're like, I can make this point best as the trial lawyer or lawyer for my client involved, and I need to jump over and into that process. That's fine. So finally, I have a list that we've all put together for you that'll come out in your handouts of pro tips during mediations, do's and don'ts. They're fairly straightforward, but as these two lawyers will tell you, every move that you're making has a meaning behind it. Every drop in your demand has a meaning. Every increase in your offer has a meaning behind it. And everyone's going to be reading into those. It's not just that, oh, the number dropped from $1 million down to 800K. There's something else being signaled. And with those signals, use your mediator. Obviously, guide your clients. You know what to start with your highs and your lows are going to be. Let's be realistic. So just quickly on the do's and don'ts, folks can read this afterwards. Focus on solutions, explain why you want, what you want, anchor the initial demands or offers wisely so that you have enough room for concessions. Acknowledge perceived weaknesses in your case. As a mediator, that's key to me. That develops all the credibility in the world. Be patient with the process, show flexibility and realism. Those are all in the do's. The don'ts, joint session for me, but if it's asked for, I will absolutely do it. It's the aggressive kind of tone deaf bargaining that's not going to get us anywhere. Litigation tactics, we're not in a courtroom. We're in a very different setting in mediation. Best or last ultimatums tend not to get anyone anywhere. That's not why you're at mediation. You're at mediation to negotiate. Most importantly, if you reach a deal, ink it before you leave for that day. Otherwise, bad things could happen. And it's never about the need to be right. We're trying to find the best solution for both sides. So I hope this presentation has been useful to folks who've attended today. We will send out this handout. There's many more slides that you'll get that we didn't put up. We wanted you just to hear the real-time conversation. Make sure to click the link for your MCLE. Anything else, folks, before we sign off here? Thank you to Doris Cheng. Thank you to Chris Scheley. Again, I'm Judge Vedica Puri. Thanks for being with us today, and this will be up on ABBA's YouTube site.
Thanks, Your Honor.
Thank you, everybody.
Thanks,
Take care.
Doris.
Your Honor. Good to see you, Chris.
Bye.
Nice to see you guys.
Bye.
Bye.